Hey, good morning, everybody. It is Tuesday. Now, here we are on Law and Legitimacy, hoping once again to make you think. Two sentient windmills tilting into a world of bluster and creating some of our own bluster, truth be known, but we're having fun at it and at least trying to be coherent most days. I'm semi-coherent today because although I didn't have the game on, I was following the NCAA basketball tournament last night because even though I haven't been in Connecticut for 4 months, I'm a Connecticut resident. And what about those Huskies, Mike?
Yeah, it wasn't much.
Five-time national championship, and they made short work of it through the tournament. They looked untouchable, even though they were an 8-loss team. I don't fully understand basketball. I mean, I don't understand basketball at all. But I'm thinking in a football world, you lose 10% of your games or 15% of your games, you're not going very far. But in basketball, I guess, like in basketball, as in life, a certain number of losses are expected, and you're expected to learn from them. But what do you think?
Yeah, well, all that matters here is that they made the tournament and then they went perfect in the field of 64. So, basketball is a long season, typically between 34 and 40 games, just depending on what sorts of preseason tournaments and how far the team goes in conference tournaments and those sorts of things. And the nature of basketball is such that you can lose a game on one night, come back, a couple of nights later and pull it out. The thing with UConn is that they have a storied program. This is their 5th national title. And so it was clear while I was watching it. I am a basketball fan. I grew up playing and watching basketball. I think I told you that basketball was my first love. And so I do get a decent amount out of watching basketball.
Can you dribble with both hands?
Oh, yeah. I was doing it the other day in the driveway for my son.
Oh, you liar. We need to see a video at some point. I can hardly dribble with one hand. I mean, I can dribble when I'm speaking, but I meant dribble a basketball. You can do it with both hands?
Absolutely. Yeah.
Really? With equal facility?
Absolutely. And before I sustained my injury late in high school, I was, for the better part of the word, I was ambidextrous as that stuff goes. So left, right-handed, played basketball very competitively for a long time. It's how I forged a lot of relationships, learned a lot about myself, learned about adversity and how to push through it. Also learned about the poetry of discipline, freedom through discipline. So there's a lot to be gleaned there. I loved watching UConn last night, simply for the way that their offense moved. I won't get too technical with it, but I was texting with a couple of people, and we all agreed that, watching the double high screen motion offense from UConn just, put the Aztecs in a box that they couldn't get out of. I told my wife when it was 20-12 that this game was over, and she looked at me. She was like, "What are you talking about?" I said, if you just watch the movement, you watch the players, even if the Aztecs make a run here, because basketball is a game of runs. But if you watch the way the players are moving and the decisions that they're making, the shots that they are creating for themselves, respectively, you can easily see who is going to be the victor over the course of 40 minutes. So congratulations to the Huskies. I've got one of my best friends. He was, one of the groomsmen in my wedding. He's a former UConn football player. And he came down to Raleigh in the fall, and state smacked his Huskies all the way back to Connecticut. So I think he actually went to the Final Four. So congrats to him for the experience of being in Houston and getting to see his alma mater. I think he was hanging out with the likes of your boy Ned Lamont.
Oh, okay. Let's move on. I mean, talk about a buzzkill. I was thinking it was great to be a nutmegger.
And Kimball Walker too, right? Kimball Walker with the famous last-second shot in the tournament years ago, and former Charlotte Bobcat before they turned back into the Hornets. He was a UConn Husky. So a good ending. Again, the Aztecs have made a lot of their program in recent years. And I think that there was an interesting storyline around COVID with them a couple of years ago in 2020. Many in the Associated Press thought that it may be their season. And then they were forced to forfeit a game based on a COVID positive result, and thus went their season. So nice to see that program rise from the metaphorical ashes and get back to the big game. But I think that when it comes to the story of a program and the history and the tradition, UConn was leaps and bounds above them, and it showed last night.
Well, congratulations to the Huskies. Speaking of getting back to the game, I
Look,
don't know if we're
look,
ever going to finish.
and
I
in
don't
the
know if
chat here, everybody is lucky UNC kept themselves out of the tourney. If not, banner number 7, Matthew Kyles is talking there, but he does say Boyer is a hooper. So there's some independent confirmation for you, Norm.
All right. Well, that works for me. Hey, look, I'll take your word for it. But someday we'll play horse, and you'll be surprised that I can dunk a shot. But listen, so USA versus Bigs. We're day 60 something today. More sealed proceedings yesterday. And because they're sealed, I can't talk about what occurred. But as I said to one of the prosecutors yesterday, as we were mulling, what in the world is going to happen next in this crazy case where there's been a little bit of everything, I said, you do realize it is the defense's goal and objective to muck up the trial by any way possible to avoid a conviction by any lawful means. I got the memo, he said. So, we're still hopeful. We hope to resume evidence today. And it looks as though we're going to close sometime late this week, early next week. And with any luck, we'll do closing arguments next week. We began our first of several charging conferences yesterday to try to come to some understanding of what the jury will be told about the law. And we had very interesting discussions yesterday about jury nullification. The court is not going to permit it. And I reminded the court that the policy against jury nullification is inconsistent with the Reserve Power Amendment of the Bill of Rights, the Ninth Amendment, which retains certain powers to the people unless otherwise given to the government. And there's nothing about the court's policy perspective and then the court's disdain for jury nullification that in the Constitution, and therefore we should have the right to nullify. The judge looked at me with a twinkle in his eye and sort of said, good luck with that. But while we get to that topic of what to do when the Constitution gives people certain rights and government seeks to claim them, let's talk about Donald Trump today. I had a more or less sleepless night last night, and I don't know why, but I guess part of it was thinking through all the moves in the Donald Trump case today. And it occurred to me that he really should win on the issue of a gag order, and there should be no question about why he should win. And I expect that if Judge Juan Merchan issues a gag order and Trump takes an appeal, it'll go to the Supreme Court. And this is how the case should be decided. Regular listeners to Law and Legitimacy know that Mike and I are sort of constitutional fetishists. We take the United States Constitution seriously, do not regard it as a source of sexual gratification, but regard it as the fundamental law of the land. And so then the question becomes, well, how do you read that thing? That Constitution, and how do you interpret it? And as law students and lawyers know, there are various schools of constitutional interpretation. Obviously, when the words are plain and their meaning is self-evident, you almost have an acceptable way to determine the meaning of the document. But sometimes you have to rely on the intent of the framers or the structure of the document as a whole. And what does it mean to talk about the Constitution structure? That's what we're going to talk about here today. So Donald Trump has been indicted. He's going to appear. He is in New York now, so forget all the extradition talk. He will appear at the Center Street Courthouse, I believe, this afternoon, and he will appear before Judge Merchan, where he or his lawyers will enter the words "not guilty," I presume, in response to an indictment that they will be unsealed. We will learn what the charges are, and then a schedule will be set for further proceedings. The people of the state of New York, in the form of Alvin Bragg, may ask for a gag order. They may ask for an order from the court that restrains Trump from speaking about the case, or at least about trial participants, and directs his lawyers to do likewise. Would such an order be lawful? I've mentioned to regular listeners that my office has twice litigated these issues to the highest court of the state of Connecticut, the Connecticut Supreme Court. In one case, we asked the Supreme Court of the United States to intervene. It didn't. In the other case, the client killed himself before the issue could be decided and then therefore became moot. But here's what's at stake. The structure of our Constitution separates the federal power into three branches: judicial branch, legislative branch and executive branch, and they have differing roles. State governments have followed that structure as well. So in a separation of powers context, you have government that have powers divided between different offices, and then you have different governments that overlap, the state and federal government. The highest law of the land is the United States Constitution, and in the supremacy clause of the Constitution, it is referred to as the supreme law of the land. It trumps all other laws, no pun intended. So, how is the federal Constitution structured? Well, we have federalism, we have separation of powers, and we have a Bill of Rights. And I know this sounds trite, but I really want you to think through what I'm saying. The very fact of government is the mystery that a constitution accounts for. It says certain individuals are going to acquire power, and that is the ability to direct what others of us do. And when that power is exercised according to law, it becomes authority, and we are obliged or obligated to obey what they tell us. And if we don't, there can be consequences. So Donald Trump has been hauled into a state court to face charges unknown at this point, but presumably, according to the press reports, related to his firm's handling of money to Stormy Daniels to remain silent about an alleged affair he had with her in 2006. But forget the ancient character vintage of the act. So from a constitutional perspective, we have an individual presented in a state court accused of a crime and now being required to answer to that crime or to that accusation in lawful process in a courtroom. His lawyers can challenge the grand jury indictment. They can file motions to dismiss on statute of limitations grounds. They can argue about what they can discover and what the case will look like. And eventually they'll likely, should the case survive, be a trial where a jury will sit in judgment of not of Donald Trump, but of the state's case, whether the state can prove its accusations beyond a reasonable doubt. All of these steps of the proceedings are elaborate, are fact intensive, and have rules governing how the parties can proceed. The court, some of those rules are constitutional in nature. Some of them are statutory in nature, meaning they come from state statutes. Some of them come from the judiciary itself. In other words, these are judge-made rules. And a set of judge-made rules that I want to focus on today is the court's inherent supervisory authority. So a state court or a federal court has to decide the case or controversy before it. And when I say court, I'm referring to the judge. And the judge is given certain powers to assure that the trial takes place. The trial must take place within the bounds of the Constitution, both federal and state, and then any statutes that are applicable and any rules of court that are applicable. But independent of all of those is this inherent supervisory authority to see that the parties get a fair trial and that justice is done. And so gag orders typically come or arise from a court's as to trial participants other than lawyers. They typically come from the court's inherent supervisory authority. What the hell? Yeah, and Donald Trump, if you're listening, he's thinking, what the hell is that? And I mean, it's a good question, even for somebody other than Donald Trump. What is the court's inherent supervisory authority? Well, within the separation of powers context, it's its ability to see that it gets its work done. No set of rules, no constitution, no set of statutes is
the show must go on as a general notion.
Yeah. Bottom line, that's it.
Pushing forward.
So, lawyers have professional obligations not to say certain things during a case, and I've been careful not to overstep those bounds as I comment on the Biggs case, because there's a trial going on, and although trials aren't supposed to watch stuff, you still have to be careful, or jurors aren't supposed to watch stuff, you're still supposed to be careful. So I am. But trial participants, that is parties, they've not sworn an oath associated with the practice of law, and they owe no general obligation to the court other than to obey its orders. So, in the absence of a gag order, Donald Trump is free to say anything that the law permits. He can call Fat Alvin Bragg names. He can cast aspersions at Wicked Juan. He can talk about the deep state. He can do, he can say the judiciary stinks. All that stuff. Fat Alvin can't. What if Judge Merchan says to Trump,
that collar can't either? You know what I mean?
Hmm?
That collar can't either.
Yeah. What if Bragg asks Merchan to gag Trump, a trial participant? Can he do it? Well, the judge can say, well, I have the inherent supervisory authority to do so. And, this was done in the Fotis Dulos case in Connecticut. I don't want to say more because I'm not supposed to talk about that case either. But in the Alex Jones case, Jones got on the air and he started mouthing off about his adversaries, lawyers, the plaintiff's lawyers, and the judge used her inherent supervisory authority to try to sanction him. And we took an appeal saying he engaged in protected speech. The court had no authority to limit its speech. The state Supreme Court said, yes, it did, that it had inherent power over trial participants. And we wanted the U.S. Supreme Court to hear that issue because we thought it was patent bullshit. They didn't, and I suspect it had to do with the fact that it's the Alex Jones case. Donald, he's in court today. He's running for president of the United States. He didn't pick this fight. Alvin Bragg did. He's a citizen who is enshrined with what? He's enshrined with rights guaranteed to him by the Bill of Rights. And here's the rub, and you won't hear this in law school almost anywhere. You won't hear this on almost any other podcast, but newsflash. The Bill of Rights is a set of personal rights that belong to the people. The government does not have protection under the Bill of Rights. The Bill of Rights protects us against government. So Donald Trump has a Sixth Amendment right to a fair trial. He has a First Amendment right to speak. You cannot abridge his right to speak by saying you're protecting his right to a fair trial because it's his right to waive. If he decides to run the risk of inflaming the jury pool by running his mouth, that's his right. The government doesn't have a Sixth Amendment right to a fair trial. It has a right to fair proceedings that springs from the court's inherent supervisory authority. If Donald Trump wants to speak, and he wants to speak because he has a First Amendment right to speak, my view is the First Amendment limits everything within its reach, and it reaches everything that any government does. Thus, from the concept of federalism, it is a substantive limit on the power of federal governments. As it has been incorporated or applied to the states, it is a substantive limit on state government as well. So if Juan Merchan seeks to impose if Wicked Juan seeks to impose a gag order on Donald Trump, in my view, has every constitutional right to continue to speak. Now, it could happen that a gag order is imposed. Trump violates it. There's something called the collateral bar rule. You're supposed to obey a bad order until you can get it reversed. I doubt that Trump would. So Trump could, have a showdown with the court where the court could hold him in contempt. I think the more likely course is in the event that Merchan issues a gag order today or at any time in the near future, Trump's lawyers will go immediately to court to get injunctive relief to freeze that order and then take an appeal to protect Trump from the prospect of going to court.
Putting Justin Carta's YouTube comment here on the screen and lobbing that to you, Norm. Worst outcome for 45 today?
There isn't one. I mean, the worst outcome for 45 today, he's in the limo on the back in the back seat of the car. He says to the driver, "Stop there." They pull into the McDonald's drive-through. He takes one of those cheeseburgers he loves out so much and squirts a bunch of ketchup onto his
I was
suit.
going to say that they just tell him that the McFlurry machine isn't working.
Yeah. No, I mean, there is no bad outcome. It's all an upside for Trump today. He will go into court. There'll be much media fanfare and hoopla. He'll go through the clicks of all the photographers and he'll have statements to make. He'll appear in front of the judge. He'll probably defiantly say not guilty. If he's well tutored, he won't say much more than that. If I were his lawyer, he might not even say that in the judge's presence. I might say my client's invoking his right to remain silent. He's not going to enter a plea or respond in any way, shape, or form to anything that you say here today. You can enter a plea on his behalf. And so he's coming home. There's not going to be a bond. He's not going to get locked up. He's not going to get put into a cell. He will be booked. And so I suspect the worst part of the day for him will be that there'll now be a booking photo of Donald
Dave,
Trump.
so I want to make sure that we give up-to-date news, because last night it broke through Yahoo News, which I've just put on the screen, that there's allegedly going to be 34 felony counts within the indictment. But in this story, it also says that he will not be put in handcuffs. He won't be placed in a jail cell, and he also will not be subjected to a mugshot. So we're not going to get any of that, which I think is overall good. I do want to go back, though, because there was some comment on Twitter that you responded to on the subject of a gag order. And I think the comment was something to the effect of, why is it that we should care about a gag order? The judge wants to control this from becoming a circus, blah, blah, blah. And when we talk about the Bill of Rights, the First Amendment exists within the Bill of Rights, right? And the title that we have here is that the Bill of Rights trumps the separation of powers. And in this case, I think if any of our viewers or listeners get into a conversation with somebody who tries to say that, the rule of law is supreme, right? We can't make special exceptions for blah, blah, blah. Yes. However, this is not that easy of an issue. And in this case, Norm, I think it's important to maybe talk a little about the federalism, because I did respond to one of those comments underneath your answer and said that even if Trump is convicted of this crime, it's a state level crime, that does not preclude him from holding a federal office or for running for federal.
No, that's exactly right.
Right. And insofar as that goes, his First Amendment right to speech is incredibly important and should not be curtailed for a state level charge that does not otherwise preclude him from running in this election. And if he is hampered in running in this election because the court sees fit to issue a gag order to prevent a circus or a media scrum, that is at odds completely with the fact that 75 million people voted for this man in the 2020 election.
Well, I want to depoliticize this, though, Mike, and just talk about it in terms of legal concepts and legal fundamentals. I did see that tweet, and the suggestion was, why should Trump get special treatment? If there are gag orders for everybody else, why shouldn't there be a gag order for him? And I said, well, on its face, because the First Amendment protects speech, and political speech is the paramount value, the one the founders most likely had in mind when they guaranteed freedom of speech. And there can be no more political speech than the speech of a candidate running for office. But as I thought about that answer, I thought, realistically, I don't think that there should ever be a gag order on a trial participant. And I think that's the issue, believe it or not, that the United States Supreme Court has never really addressed squarely. And this case, people of the state of New York versus Donald Trump, will present it with an opportunity to do so should Merchan issue an order. And the argument is simple, and that is, if the Bill of Rights is intended to protect people against government, and government decides to prosecute a person, that person has the power to speak out against the government. That person has the power under the Sixth Amendment to demand the rights guaranteed them under the Sixth Amendment, which includes a fair trial. Now, it could be that in a judge's mind, a defendant's right to speak out and his exercise of that right undermines the defendant's right to a fair trial. But the judge doesn't get to substitute his or her judgment for when to exercise that right for the defendant. And if the state says, well, what about our fair trial rights? This is where the rubber meets the road. And the argument has to be and should be that the Sixth Amendment is a personal right that guarantees to a defendant a fair trial. It guarantees nothing to the state. And thus, a defendant who chooses to aggressively defend out of court himself as the trial participant cannot be abridged by a gag order. His lawyer, yes, because the lawyer is an officer of the court, but the client, not at all. So I think the Trump case becomes as he would say, hugely significant, because it's going to raise and potentially frame this issue. Now, Mershon is no dumbbell, and he may not entertain a gag order against Trump to avoid framing this issue. I think that given Trump's temperament, he is likely Mershon, his hand is likely to be forced, because in a matter of no time, the judge will direct his attacks against Mershon, who has, after all, presided against other cases involving the Trump organization and issued rulings that Donald disagreed with. And so, the judge may say from the bench, Justin Carter says, could the judge bring up his presser that's scheduled tonight? Well, of course he can. The judge can do whatever he wants. He's sitting up there with the gavel in his hand. And he can say, Mr. Trump, I'm directing you not to speak out against these proceedings at your press conference tonight. And Donald's response to that should be absolutely nothing. And his lawyers should run to a court to seek injunctive relief against what would be a prior restraint. We do not have prior restraints in the United States against private parties, and we never, ever should. The court.
Go ahead. Sorry.
No, the court should not be in a position of substituting its judgment about what's good for a defendant for the defendant, as advised by counsel's sense of that. And Judge Mershon cannot say, I'm issuing a gag order to assure under the Sixth Amendment the right to a fair trial, because that's Donald's right, not the court's, and the state doesn't have a Sixth Amendment right.
Absolutely.
To a fair trial.
And Norm, you do such an excellent job of making sure that people understand who is in charge of asserting those rights and stewarding those considerations. I do want to get to a few comments here in the Rumble chat. We've got quite a few people watching live this morning. So hey to all the to the usual suspects. BTL's here, T-Girl's here, Matthew, Kyle. You've been a usual suspect this week.
Yeah.
Nice to see you back. Lawyer Will's in the chat.
Lawyer Will.
Thinking Man in the chat as well. And Lawyer Will says, isn't an NDA a quote-unquote hush money agreement? When did we start calling NDAs hush money agreements? and look, that I think that is just being charitable to those who have a political axe to grind, right? It's something to frame the issue, and they've done it well. It's rhetorically, it works. But you're right.
Taking the politics out of it and focusing just on the law. If we are the masters or mistresses of our own destiny, we have the right to contract away, that is to bargain away our rights to do certain things for consideration. And we can decide to speak or not for consideration, for payment. A non-disclosure agreement is an agreement to refrain from saying something about something you have a right to speak on in exchange for money. There is nothing unlawful about an NDA. Now, if you procure one in the course of an ongoing criminal investigation to frustrate the investigation, that's a different matter. But as a general matter, an NDA is just a contractual arrangement between two parties.
That's right. And I've talked about that before, offer, acceptance, consideration. Norm is talking about the notion of consideration, and consideration can be, your agreement to make an affirmative act, but it can also be your agreement to forego a legal right that you would otherwise have. And in this case, within the context of an NDA, it is to speak freely, right? So on a specific topic. So you may bargain for certain other consideration from a counterparty by promising and agreeing not to exercise your right to speak about a certain narrow topic, right?
All right.
And that's how NDAs function. A couple of other things here. We've got, let's see, it was BTL. BTL says, is there any truth that it is a felony to leak the charges? Is it an example of how the prosecution can strategically leak info with no repercussions?
Well, there is, I don't know if it's a felony, but it is against the law. Grand jury proceedings are supposed to be secret, and they're supposed to be secret because that's where the government presents information about you and whether you should be charged with a crime. Learning that you're being investigated is damaging, as every bit as damaging to most people as being accused of a crime, because most of us never get investigated. So, whoever will never know who the leak was. And, should there be a strict liability regime such that if grand jury information is leaked, the state pays in some consequence? Maybe, but we've never gotten that far. Grand jurors, they can talk about what they've done. They can't talk about their deliberations. And so sophisticated news organizations typically have reporters in the hallways at courthouses, following, or witnesses rather, in front of the grand jury. Excuse me, not grand jurors, can speak about what they've talked about. And so a sophisticated news organization will have a reporter follow witnesses down the hall, and some witnesses will say, yeah, they asked me about X, Y, and Z. And that's where most of these leaks come from. Bragg can't do it. Participants in the grand jury process can't do it, but witnesses can. And it's largely for those same First Amendment reasons. I'm summoned to a grand jury to testify. You see me walking out of the room. Hey, Norm, what did you talk about? That's my right to decide whether to tell you about it or not. It's not the government's right to stop my lips. And so there come times where the guarantees of the Bill of Rights have real teeth, and they're supposed to take a bite out of the government's ass. This is one of those instances.
That's right. I know we're running up against it here. I wanted to briefly introduce a topic that I know we will be talking about tomorrow, if provided that there are no explosive developments in the Trump world. I know the indictment will be unsealed today, so I doubt seriously that this will take up most of the time tomorrow. But there is an article in the USA Today, and it was written by none other than Jonathan Turley, and it's on the topic of artificial intelligence, and in particular that artificial intelligence has made false allegations of sexual misconduct, sexual harassment, not only against Mr. Turley, Professor Turley, but others as well. So this is in USA Today. For those of you who are audio only listeners, you can go to USA Today. Their website, the title is ChatGPT falsely accused me of sexually harassing my students. Can we really trust AI? There's some troubling stuff in this article. It kind of goes off the deep end with this stuff, and it goes back to what we discussed last week, Norm, on the topic of liability for acts of GPT and similarly situated, we'll call it, AI architecture.
No, it's a huge problem. I mean, Turley, you got a call from a respected colleague. I think it was Eugene Volokh.
Indeed, it was. I was trying to say that little bit. That's what I like the most.
And Volokh says, what's it? You were accused of sexually assaulting a student on a trip to Alaska, and Turley's response was, "Well, that's news to me, because not only did I not sexually assault the student, I never went on a trip with students to Alaska." But yet somehow in the ChatGPT algorithm,
I never taught at Georgetown. I teach at George Washington.
George Washington, thanks, wherever it is.
Well, no, he said that. It was like they reported Georgetown. He's like, I've never taught there.
So so ChatGPT, and a respected and authoritative source for those of you enthralled by the mystique of AI, is reporting things that are defamatory per se and damaging to Mr. Turley's reputation. What can he do about that? We will talk about that tomorrow or later in the week or sometime soon, because the liability of AI, to the degree that it begins to assume sentient and independent powers, it shouldn't be acting with immunity or impunity when it harms others. Turley's been harmed. What should we do about it? That's something America needs to think about as we try to make America think again.
That's absolutely right.
Before
we get out of here, I just want to take a moment to plug Norm's upcoming comedy show at Mohegan Sun there in Connecticut. That's May 18th. We talked about this, I think earlier this week or last week. But I'm myself considering making a trip up to the Northeast there for that. And mostly wanted to take a second to plug this as well. Some people have said that the Rumble app does not allow these subscriber badges or the ability to purchase a subscriber badge. I do know that it works on the desktop. So if you are so inclined, please consider getting a Rumble subscriber badge for Law and Legitimacy. You can let us know that you did that, but you will get a specific badge. So when you show up in the chat with all of your other friends, you will have something a little bit more than what you have as a normal live listener. Otherwise, you can find us on Apple Podcasts, Spotify, Google Play, Overcast, anywhere where podcasts are found. We're here every day, Twitter Live, YouTube Live, and Rumble. So please subscribe, and most importantly, put a thumbs up on the video. That really helps us. We are seeing some pretty decent and sticky growth in the last couple of weeks, so we're excited about that. And we're also excited for Norm to finally get out of this case in D.C. so that we can begin putting some stuff together for you all.
Yeah, someday I'm going to be home. I was brushing my teeth thinking of those Vermont woods, missing them bad. I missed winter up there this year. The snow will probably melt by the time I get home. But I'm on my way to court, Mike, and you know what that means? Objection!
Overruled, counselor. What rule are you even citing?
I'm ready. Thanks for
All right.
listening, folks. Talk to you tomorrow.
See you in the morning, Norm.